I've placed that bundle there just to give context to what we're being asked to do. I'd be misleading the Dáil if I said I've read that Planning Act. I've done my best to read around it. I've done my best to read the memorandum. I want to thank the library, as usual, for producing 2 digests under extreme pressure. And I want to thank the staff in the department before I absolutely criticise this bill and express my serious concerns about it, but it's certainly not in relation to the staff. I make my comments today in the context of yesterday's report in relation to the tipping point for our climate. 200 scientists said we're at a pivotal moment for humanity, and they outlined five major tipping points already at risk of crossing tipping points at the present level of global warming: the Greenland ice sheet, the West Antarctic ice sheet, warm water coral reefs, North Atlantic subpolar gyre circulation, and permafrost. Serious warning here yesterday in relation to it. That's the context. And I have searched in vain for a recognition that we are facing an existential crisis in relation to climate change and biodiversity, although we declared an emergency, I think, back in 19 now. I also despair of the narrative that accompanies this bill. Again, no reflection on the staff, but an absolute reflection on government, spokespersons, spokespeople, and certain backbenchers who continuously and reiterate the narrative that the planning system is in trouble because of objectors. I don't know any such word as an objector. I spent 17 years of my life at local level, and I know that the people that I knew put in submissions at great cost to themselves. Huge effort to put in a written submission. We never ever made provision for oral submissions. I have never met an objector for the sake of an objector. Perhaps I'm a little innocent in view of the show the other night, or the RTE programme, but I've only met concerned residents and concerned citizens at the end of their tether. And I think if TDs were honest in this, they would agree with me in relation to that. And then we look at, I think there's a title there, A Solution in Search of a Problem, which I'll come back to. And we look at the regulatory impact analysis, which I'm not sure why we do this, because there's no option. I know we have to, so Minister, don't come back and tell us we're legally obliged, but my difficulty is in relation to then do no option or do something and the costs. But what's interesting about this, when it was finally published, option 1, do nothing. Benefits. The majority of Planning and Development Act 2000 is considered to be working efficiently as is and well understood. And option number 1 does not require any phased implementation of new policies. So I'll just repeat that. The majority of the Planning and Development Act is considered to be working efficiently as is. And so you'd wonder why we've produced this here. And part of that is to do with the open door that different lobby groups have to this government and successive governments. And in collusion with ye have put forward the narrative that the biggest problem in relation to housing or in relation to strategic developments are objectors, with absolutely no evidence of that. And so just practically, if I look at this, an answer recently, this is on the 6th of December, an answer in relation to a question on lack of capacity and lack of planners in the system. The LGMA submitted a report entitled Business Case. Imagine they had to go to the trouble of putting forward a business case for resources for the planning function of local authorities in 2022. And what did they identify? Over 500 staff. A shortfall of over 500 staff. Can you imagine trying to run an effective planning system? And notwithstanding that, the regulatory impact analysis tells us it did pretty well. That's a testimony to the staff that are there. A shortage of 500 staff. That's that one. Then we have the Office of Planning Regulator, who made a submission in relation to the pre-legislative scrutiny stage. As the department's own analysis has shown, which we're not privy to, of course, the planning services, as it were, is likely under-resourced by probably a third in headcount terms, and with fee income not having been revised since 2001, our planning service is chronically underfunded. The historic and structural underfunding of our planning process is all the more remarkable when one considers how central the planning process is to building anything in this country: homes, infrastructure, schools, flood defences and renewable energy. It goes on to say some of the points made by the plan, and he makes a range. Some of them I agree with, some of them I don't. But what he does point out is that he doesn't agree with imposing fines for delays in the statutory limits. So let me just look at this. So before I just go on to the nitty-gritty of it, why I mention climate change is now more than everything, we need the active participation of residents and citizens, don't we? In fact, in my experience, change has come from those committed people on the ground. If you think of the Climate Mitigation Plan, and it was taken to court, I think by the Friends of the Environment, we can only learn from them. They put that stress on themselves, and the court upheld their application, didn't they? And they said what? That the bill was, citizens were entitled to know what was in the law. And the mitigation plan was held invalid. We look then at this, and we're trying to, as TDs, do our best, because we're constantly reminding ourselves that we're here to legislate. So this is the third largest piece of legislation in the history of the state, comprising 712 pages, 22 parts, and we know there are further parts to come, which haven't been subjected to pre-legislative scrutiny, 501 sections and 6 schedules. The explanatory memorandum itself is 124 pages long. The legislation will affect all our lives: housing, roads, renewable energy, environmental and architectural conservation, and very importantly, access to justice in planning matters, which I'll come back to, because that's exactly what we're restricting and reducing. The briefing note from your department tells us one of the primary objectives is to bring clarity, consistency and certainty. We used to talk about the 3 R's, now we're talking about the 3 C's, and an additional one, coherence. The whole idea is to save time, as one of the previous speakers said, that the planning is a mess and there are delays. Well, one of the major delays, as I've pointed out, is absence of resources, or lack of resources, lack of staff. Appointments to Board Pleanála, that's a reflection on the minister that appointed the person at the time, that didn't seem to recognise when one might have conflict of interest or one might not. But that has gone through the criminal courts and that has been dealt with. None of that was caused by people nor by the good staff that work in Board Pleanála. But we come along with this legislation and we change the title. I see absolutely no reason for changing the title on Bord Pleanála. We all know it. Even people with little Irish know it, and they say it proudly. It was a body that we had trust in. I didn't agree with all their decisions, but we had trust in them. We knew there was a second tier. We knew when decisions were made rushed at local level because of lack of staff or extraordinary pressure on staff, there was a second tier to look at it. And we're talking about saving time here by reducing the participation of the public. And then we have this documentation from the regulatory impact analysis from the department telling us we're actually expanding public participation. Now, for God's sake, or the goddess or whoever one believes in, how could we possibly say that we're expanding the opportunities for public participation when we're doing the complete opposite? There might be in relation to the preparation of plans and the 10-year plan for the local authorities and so on, which I've no difficulty with at all. But I've the most serious difficulty with the twisting of language when it comes to we're expanding the role of residents and people who are interested when we're doing quite the opposite. And just when we go back to the 3 C's, The former Chief Justice has told us, unfortunately, he hopes that he doesn't have to say, "I told you so," that is going to lead to further litigation. All of the contributions I have here and read tells me that this Act is going to lead to further litigation, what they call satellite litigation, because of the confusion, because of the failure to define terms precisely, because it's centering power in the hands of the minister, whoever the minister will be on the day, leaving a huge amount of power in relation to regulations and so on, and that this will be challenged. Nowhere in this have I seen the context given of climate catastrophe and how the planning has to deal with that and allow maximum participation. Nowhere have I seen the Aarhus Convention set out, which was signed by us in '98, ratified in 2012. I've done a word check. My office has done a word check on it. I think it's mentioned 11 times, specifically mentioned just the Aarhus Convention or what it is, but no overall setting out of the obligations on us under the Aarhus Convention, which we ratified in 2012. That is certainly going to be challenged on that basis alone. That has become part of European law and part of our law. I would have thought somewhere in that vast 700 pages it would have been set out, that we would have learned that much by now. There isn't a mention of it. I keep an eye on the cost of tribunals, and two in particular in relation to planning. The Tribunal of Inquiry into certain payments to politicians and related matters concluded, and we're up at 67 million. I skip all the other ones because they're not relevant to the planning. And then we have, that one was Moriarty, and then we have the Mahon one, 97 to 2004, 142 plus million, and ongoing. And of course, that has nothing to do with that, except what it has to do with it is the importance of the public participating, as set out in the Aarhus Convention, in relation to get maximum information, maximum participation in the decision-making process, and access to justice in the courts. And in fact, the judge, I can't remember his name, from one of these tribunals is quoted as saying, "We need maximum accountability, maximum participation, because corruption blossoms in the dark." And yet, what we're doing here is reducing, against all of the submissions that have come in. And you know, we champion this, the Science Foundation Ireland, regularly making contributions here through various TDs, and we have Science Week, and we should base our decisions on evidence. There's a complete lack of evidence here as to why we need to change the judicial review process and restrict further the ordinary person's access to that. I have seen it set out nowhere, Minister. But what I have seen set out is that it's minimal. The judicial reviews are minimal, something like 3 to 5% on an annual basis, set out by the Office of the Planning Regulator, set out by the different environmental groups. So a narrative that judicial review is causing the problem is completely false, misleading, and against everything that I stand for. And particularly in a Dáil that prides itself on Science Week and basing decisions on evidence-based decisions. Could you maybe, I probably won't be here for your concluding remarks, but I will read them. Maybe you could come back and set out the rationale that has led ye to restrict judicial reviews. On what basis? Bearing in mind that those submissions have repeatedly itemised the previous occasions when you tried to do this. First of all, in 2000, in relation to getting rid of the ex parte, you had to re-put it back in 2010. You also had to do something similar in relation to asylum and immigration cases, where the narrative was clogging up the system, clogging up the system. The reality, you had to go back and reinstate. And here we are in 2023, getting rid of the ex parte, which acts as a filter system, which allows barristers and solicitors to bring forward bona fide cases, which is the only avenue open to people on the ground. And you're restricting that. And with a SOP to the Green Party, you're setting up an administrative scheme that will be the hands of the minister and however it's set up, and taking it from the courts. Well, I put my trust in the courts any day in relation to awarding of costs, or the withholding of costs, or their analysis of whether there's a substantive case to go forward in a judicial review. And you're restricting all of that. You're also restricting the declaration in relation to whether a development is an exempted development or not. Again, that has been cited in the court as it was, and you're making it worse, as it was, anyone could go forward and seek a declaration, whether the neighbour next door or up the road, whether it was an exempted development. But if they didn't do that, then they couldn't put in a submission at Bord Pleanála level. And within that restriction, the High Court has commented that this is very difficult to justify under the Aarhus Convention. And what you have done is gone even a step worse, and you're saying that a third party cannot look for a declaration on exempted development. No rationale, no reason given. It will be the person, the developer, or the person with permission to develop it can seek the declaration. The recommendations there are many from the various groups saying, don't do this, this is wrong. Don't do this with judicial review, this is wrong. And please show us the rationale and the basis for it. And nowhere is it to be seen. The restriction on residents' associations and the onerous and burdensome criteria here is nothing short of shocking, actually, when we're utterly reliant on people to come forward, because the enforcement by local authorities is absolutely appalling and abysmal. A huge amount of that is the lack of staff. The lack of staff in local authorities. I was up in Achill with the Irish Committee less than 3 weeks ago, and we checked with the new county manager. I still call them county managers. It appeals to me rather than a pre-Vimana. I think it captures better what a local authority is there for, to serve the people of Galway, to serve the people of Mayo. It's not a business. And he confirmed that they have, I can't remember the chair is there, but he can't comment, but he was there at the time in relation to the number of vacancies for planners in Mayo County Council, and also the same in Galway City. The Irish Human Rights and Equality Commission, very respected organisation, they highlight to keep the ex parte system, with the court retaining the discretion to direct that such an application, if heard on notice where circumstances require. So the court have that discretion, you know that better than I. They can direct that it's on notice. So I'm not so sure, I've no idea why you're doing this. They also make very serious submissions in relation to failure to deal with traveller accommodation, which has been briefly mentioned by Deputy Owen O'Brien. Nowhere is that reflected. They talk about the administrative scheme. And there are difficulties with that. And they talk about getting rid of the Court of Appeal only for this area of law. Can you imagine getting rid of the Court of Appeal just for this area of law, and no rationale anywhere? No explanation why that's necessary, no idea what it's based on. As I mentioned already, the former Chief Justice Frank Clark had serious concerns that it will lead to a lot more litigation. It has already had unintended consequences in another area of law, that's namely in asylum. So we have the experience of messing up there, and we still haven't learned. And I'm going to finish by thanking those who went to the trouble of putting in all those detailed submissions. I read every single one of the submissions. I didn't read the whole 700 and something pages. I didn't have the time. But what I've read has raised serious concerns for me that what we're doing is business as usual, when actually what we need is transformative action on every level. I'm the first to promote renewable energy. But the transformative action we need has to be with the people on board. And what we're doing here is othering them. They're the problem. They've created the mess, not the government that brought in strategic housing developments. And most of them were judicially reviewed. The ones were successful. And at the time, the local authority in Galway warned you, don't do this. You're taking up our time and it's going to Bord Pleanála and an absolute mess. And then you blame Bord Pleanála for that. Well, I don't. And I don't blame the staff and the local authorities, but I blame successive governments. And I abhor the narrative that's going out that people and serial objectors are to blame for a housing crisis and for the failure to promote and develop serious, important infrastructure projects.